We'll take up Senate Bill 171, which is the PCS that we discussed yesterday. We'll take up Senate Bill 171. We don't need a motion for that, do we?
No.
If so, Senator Daniel moves. Okay. All right, and there is an amendment for that. Would you like for the amendment to be handled
Mr. Chair,
first?
first, if I can just go through the bill.
Yep. You're recognized.
All right, so I'm just going to run through these sections. So this is a DPS agency bill. So all the requests came from the agencies within DPS. So those are State Capitol Police, the Highway Patrol, National Guard, and then the Samarkand Training Academy. So just going down real quick, Section 1 was requested by the State Capitol Police, so that allows the State Capitol Police to provide security for state property throughout the state. And this language was worked out with the sheriffs to address their concerns. Section 2 was a Highway Patrol request that is a clarification on the Second Chance Act. Section 3 was requested by the Highway Patrol, dealing with changing national missing and unidentified person systems reporting requirements from 30 to 90 days. Section 4 was also requested by the Highway Patrol, so it expands individuals who can be included in a missing persons alert. Section 5 was requested by the National Guard. Now, this is a section that yesterday the district attorneys had expressed some concerns with, and so the amendment takes care of their concerns. So this allows access to unredacted law enforcement and medical examination records to assist in military investigations and court-martials. Section 6 is also National Guard language, ensures that the National Guard maintains the authority to convene and prosecute court-martials for sexual assaults perpetrated by one of their members and exempt from federal special trial counsel requirements. Section 7 is also a National Guard request, ensures that any service member sentenced to confinement by a state court-martial for a sexually violent offense or an offense against a minor will have to comply with the registration laws under North Carolina's registration statutes. And then the last section is requested by Samarkand Training Academy. It gives Samarkand the authority to adopt a fee structure for the room and board when agencies come in to do training and stay in their dormitories, and that just aligns with other state training facilities. So that's the explanation of the bill, and I think Senator Britt is going to deal with the amendment, Mr. Chair.
Thank you, Senator Daniel. Senator Britt moves to amend the bill. Senator Britt's recognized.
Yes, Mr. Chairman. You should have the amendment in front of you. It's S-171-ACK-8. Just amends the bill on page 3, lines 25 to 51, where it states the National Guard Staff Judge Advocate may request criminal investigations from the district attorney. This just changes that to from a law enforcement agency. This is a consensus amendment that was requested by the agency and Conference of DAs.
Thank you, Senator Britt. Questions, comments on the amendment from the committee? All right, there being none, all those in favor of the amendment, please indicate by saying aye. Any opposed? The ayes have it. The bill is amended and back before us. Senator Daniel?
No more comments, Mr. Chair, unless there are questions.
Okay. I see several hands going up, so out of courtesy, I'll recognize Senator Marcus first.
Thank you, Mr. Chair, and thank you, Senator Muhammad. My question is about Section 4. You described this is the part about missing persons and when they need to be, which ones can be reported to this, I don't know how you say it, NAMUS, N-A-M-U-S. You described it as saying it expands the reporting. It seems to me it's reverse of that. The way I read it, it sounds like someone has to be missing for 90 days now instead of just 30 days before they're going to be reported to this. I assume it's a national database. And so to me, that seems like the wrong move, and I'm just wondering if you can explain that or if the agency who requested it can explain that.
Thank you, Senator Marcus. Senator Daniel,
Mr. Chair, I think the Colonel from the Highway Patrol is here. If you could address that question.
Okay, certainly.
He can answer.
Colonel, would you step up and state your name and if you can answer the question. Thank you, sir.
Yes, sir. Chairman Freddie Johnson. I'm the patrol commander, and it's good to see everyone today. Appreciate y'all's support of the patrol. To answer the senator's question about NamUs. That is the National Missing and Unidentified Persons System. So it's not going backwards. So basically what happens now is there's a lot of things. Somebody reports a missing child below 17. There's a range for older folks. There's silver alerts. Those things spin up immediately. NamUs is a national system. So basically what's happening now is the law says 30 days, but we're missing a lot of that data because we feel the missing center is basically hosted by the patrol. We coordinate that. And right now, a lot of agencies are not entering the NamUs data. So basically what that is if we find a law enforcement agency finds the reason for the extension is we deal with a lot of habitual runaways. So by entering all the data into NamUs, it's kind of a burden on local law enforcement. We figure by extending it to 90 days, we'll get more people, more agencies to put the data in there. Basically what NamUs does is it captures, if you have a missing person or like basically they find a body somewhere in the United States. So we put key information in there that describes the person, DNA. There's a lot of information that goes into that. So medical examiners and families across the country can go to that site to see if they've got a body that has not been identified somewhere in the country. So we feel, since we're the ones that host it and we're the ones that key all this data in, my team that does that feels like by pushing specifically the NamUs part out to 90 days, more agencies will use it. So basically we're giving law enforcement agencies some breathing room to get that in there, to get past the burden of dealing with the habitual runaway piece. So having said that, the other piece of that too is law enforcement agencies that deal with runaways or these first time happening missing persons cases, they have an idea, if, based on historical data, if they're dealing with a habitual runaway situation or this is something that truly needs to be entered immediately. This kind of gives them that wiggle room. That was the whole purpose of this.
Thank you, Colonel.
Does that answer your question, sir?
Yeah, I'll let Senator Marcus decide whether that answers her question or not. Senator Marcus, follow
I
up.
would love a little, 2 more minutes for some further clarification. If I can, I don't know if it's appropriate to ask my question directly or through the chair.
Well, let's try to expedite this as much as we can. So ask your question quickly, and we'll try to get a quick answer. And if not, we'll take it offline. Okay?
What I think I heard you say, sir, is that people don't want to, that there's a burden here in having to input this. But what I also think I heard you say is this means that if there is a dead body found, for example, we can't identify that person, that information now won't be put in this national database until 90 days later instead of 30 days, and that that has nothing to do with habitual runaways, right? So that doesn't make sense to me. But then also just generally missing persons, that if we have to wait 90 days before they're reported nationally, I'm afraid that's moving in the wrong direction and trying to find these missing people.
Right.
So
maybe I
Senator Marcus,
misunderstood
if
what
I
you
could
were saying.
expedite this, your question is this moving in the wrong direction? Is that correct?
Yeah, and
okay.
particularly
So
for the
we
dead
need to
body
keep moving
part,
along.
I don't think
okay.
we address the dead. Like if what we're talking about is a dead body, there's nothing to do with habitual runaways. So I'm trying to
Okay.
understand how that fits with the answer that we.
Colonel?
So to answer her question, you've got the Amber Alert system, that's immediate. So that's in there. And every state has access to that. You have the Silver Alert piece, they have access to that. So it gives them data. So, the NamUs piece, like I said, that's an additional thing. And we just feel like it'll give law enforcement agents some breathing room to make sure more of them put that data in there. Because right now we have a lot of them, we're not capturing that. So, and Senator Newton, I'll be glad to meet with her offline to, really go through this and answer more questions if we need to.
Thank you, Colonel. Thank you very much. Senator Muhammad, do you still have a question?
Just a comment, Mr. Chair.
Okay. All right. You're recognized. We'll come back to Senator Marcus if she has more.
I want to thank the Colonel for being here today. I want to thank Senator Daniel and DPS for including the update to Silver Alert related to cognitive impairment. I actually had a constituent who's a grandmother. Her granddaughter was actually had a cognitive impairment. She was missing, and she was sadly found murdered. So if we would have had the Silver Alert, then she really thinks it could have been helpful. So I want to thank you and DPS for including this in your bill. Thank you.
Thank you, Senator Muhammad. Other questions? Senator Marcus, do you have any more follow-up? I'm serious. Do you have any more follow-up? Okay. All right. Any other questions, comments? Senator Lazara moves for a favorable report. Let me get this motion correct. Senator Lazar moves for a favorable report to the PCS to 171 as amended, rolled into a new PCS, unfavorable to the original bill with a referral to Senate rules. All those in favor, please say aye. Any opposed? Ayes have it. Thank you, Senator Daniel. And I think the next one on the list was Senate Bill 445, recording court-filed documents.
If I could, just to address the last bill just briefly.
Senator Daniel.
So I know that the colonel has public safety at the top of his his mind, and he wants all the people in North Carolina to remain safe, and that I'm sure he's willing to look at this if we think there needs to be a tweak to it. Obviously, the bill wasn't perfect when it was filed because we've made some changes to it, so we're happy to do that. Senate Bill 445, Mr. Chair, this is a request from the Register of Deeds offices, and essentially, as those of you who may practice real estate know, that the Register of Deeds offices have formatting requirements for documents that are recorded. This bill just exempts certified court-filed documents from those formatting requirements. So, if some kind of an order needs to be filed and recorded in the Register of Deeds office and it didn't have a 3-inch top margin, then it's not a non-conforming document and it's exempted from the requirements. So, hopefully not a controversial bill.
Thank you, Senator Daniel. You never know. I'm seeing twirly birds. Any questions or comments from the committee? If not, I have a motion from Senator Sawrey to, let's see here, let me make sure I'm reading from the right script here. 445, favorable to the report. Favorable report to Senate Bill 445 with a referral to Senate rules.
That's my motion.
Thank you, Senator. All those in favor, please say aye. Any opposed? All right. Thank you, Senator Daniel.